Okay, well, good evening, everyone, and thank you for joining us for another edition of An Evening with the Night. Firstly, I would like to acknowledge the traditional owners and custodians of the land I'm presenting on today, the Boomerang and the Wurundjeri Woi-wurrung peoples of the Eastern Kulin Nation. I pay my respects to their elders, past and present, and extend these respects to all Aboriginal and Torres Strait Islander peoples who are joining us this evening. For those who have joined us before, welcome back. And for those who are tuning in for the first time, this event this evening is designed to keep our clients up to date with all the latest industry news and equip you with useful knowledge and skills to build harmonious and effective owners corporations. A few housekeeping items before we commence tonight. The presentations this evening are being recorded. All attendees will receive a copy of the recording, as well as the slides and any other resources mentioned when the event concludes. Your cameras and microphones have been turned off. There is a question and answer function which you can use to ask questions during the presentations. I'm joined by some of my colleagues in moderating the chat this evening, so they will be able to answer some questions as we go. There will also be some time for live answers at the end of each presentation. If we do not get your question in our allocated time, we will endeavour to answer it afterwards for you. For those joining us live tonight, we have had a last-minute cancellation and change to our schedule. Unfortunately, our insurance expert, Renee Cassidy, has lost her voice and is unable to present. Thankfully, Renee has graciously agreed to record her presentation once her voice returns, and we will share the recording with everyone once it is available, and certainly we apologise for any inconvenience as a result. With that being said, we still have plenty of insights to share across our two presentations this evening, which we're excited to get stuck into. To kick off our first presentation, I'm joined by the Managing Director of Equal Access Group, Bruce Bromley. Bruce has over 30 years experience in disability access, architectural design, documentation, and project management. Bruce also specialises in evacuation procedures and policy for people with a disability. Bruce formed Equal Access Group in 2006 to provide assistance to building owners and managers on the impacts and practicalities of responding to their obligations under the Disability Discrimination Act. Tonight, Bruce will share with us all about disability access and discrimination within buildings. So thank you for joining us this evening, Bruce. I'll now hand over to you to commence your presentation.
Thank you. There we go. So tonight's presentation is going to be fairly brief, but we're going to just touch on disability statistics. We're going to look at very briefly at the definition of what is disability. For OCs, it's critical to understand the hierarchy of legislation in Victoria. We're unique compared to most of the other states, and there's a few things that have been occurring the last probably 3 years, I suppose, which have sort of changed what the expectations were of the status quo in terms of liability and responsibilities. We're going to touch on, can state tribunals enforce a high level of compliance to federal legislation? Can you be held liable under the DDA or BCA? And what happens when things go wrong? Equal Access Group, we've got 4 parts. Disability Access Consultants. Equal Access is the capacity I'm talking on tonight. We also consult in the space of specialist disability accommodation under the NDIA. We have a range of products, both commercial, retail, healthcare, for emergency evacuation, focus on disability there, but also, as I said, a lot of consumer grade products. And then we have a number of other primarily commercial grade products under the access and safety banner. Background on me: accredited access consultant, accredited SDA assessor, accredited livable housing assessor, registered changing places assessor. I'm also a member of the Australian Standards Development Committee on Emergency Workplace Evacuation, which also applies to multi-level residential, which is AS3745, registered building practitioner, lead author of the co-author of the SDA design standards and also lead author of Changing Places standards. So when we look at disability, it's important to note it's more than just someone in a wheelchair, which is obviously patently obvious, but 90% of disabilities aren't visible. So 1 in 3 people have a disability or likely to be close to someone with a disability. 1 million working age Australians have a disability. 3.4 million or 15% of the population have a physical disability. Only 0.6% of the population use a wheelchair, and 1 in 6 Australians are also affected by hearing loss. So when we take that further, 30,000 deaf Australians use Auslan for communication. 357,000 Australians who are blind or have low vision. 700,000 Australians have an intellectual impairment. 10% of the population, including myself, have dyslexia. And more than 90,000 people have a mental health disorder. And as I said, disability is more than just, we're putting a ramp at the front of our building for wheelchair access. We tick the box. So we're looking at physical wheelchair users, but could also be an amputee, someone that's had a stroke, intellectual, autism, Down syndrome, psychiatric, schizophrenia, depression, sensory, hearing, vision, touch, neurological, epileptic, acquired brain injury, or Parkinson's disease, or multiple sclerosis, learning disabilities, dyslexia, and I don't even try and pronounce the next two, and physical disfigurement, or the presence in the body of a disease-causing organism like hepatitis and AIDS. And it's important to note some people will have multiple disabilities. Now, unfortunately, this is going to be a bit heavy probably for the next 20 minutes when we're talking about building legislation, but it's critical to have an understanding of this to understand then what your liabilities are into the future. So at the very, very top in Australia, we have the Federal Disability Discrimination Act. You'll often hear people say, my product is DDA compliant or my property is DDA compliant. There is no such thing. Disability Discrimination Act in its basic form simply says thou shalt not discriminate. Then directly underneath that, so this is for Victoria, we have the Disability Access to Premises Standards, which is Victorian legislation. And under that sits our building regs, the Building Code of Australia, which ironically is a national document, but it's triggered in Victoria by the building regs. We have the building regs, the building code, and then within the Building Code of Australia, we have referenced Australian standards. So as I said, the Disability Discrimination Act simply says thou shalt not discriminate. It's a complaint-based mechanism. So for someone to have issues with a building or building access, they can lodge a complaint with the OC. If the OC says, no, we're not going to make any reasonable adjustments or any changes, that person typically will then lodge a complaint either with the Victorian Equal Opportunities Commission or the Federal or the Australian Human Rights Commission. Can't do both. The Human Rights Commission will then try and mediate the issue. If the property OC says, no, we're still not prepared to come to the party and make any reasonable changes, Human Rights Commission is a toothless tiger and they cannot enforce any actions against an OC or building owners, which then leaves the complainant having to take a complaint to the Federal Magistrates Court at their own expense and at their own risk. So unless they can get pro bono legal advice, usually it doesn't proceed any further. Or does it? And we'll discuss that. So typical things that the DDA covers: disability discrimination, less favourable treatment, discrimination, use of devices and aids, access and use of premises, discrimination and access to use of goods, services and facilities, There is an option within the DDA of unjustifiable hardship if access can't be provided or reasonable modifications can't be made, or there's insufficient money to be able to make those changes. Unjustifiable hardship can be played as a card, but you need very strong documentation to get that through. What you will note is heritage is not provided as an option to exempt disability discrimination. So heritage is typically a state or local government control. DDA's federal takes precedence. So anyone that says, no, we can't modify our building because it's heritage controlled, forget that. We can make changes to buildings overruling heritage. Heritage consultants don't like that when we state that, but that is the reality of life. To give you an idea, and as I said, the DDA basically says thou shalt not discriminate. It doesn't say what you need to provide, how you provide it. So if we look at this extract 23, discrimination and access to use of premises, unless unjustifiable hardship applies, a person must not be discriminated against because of the person's disability or the disability of an associate. So you can't deny access, use of premises, condition or apply conditions for entry or use of such premises in the form of access to the premises by denying use of facilities in such premises, i.e. you might have toilets or amenities. In terms of conditions for use of such facilities, or by being required to leave such premises or to cease to use such facilities. So a classic one, which usually comes up a couple of times a year, someone with a vision impairment has a guide dog and they're told, no, they can't enter a restaurant due to hygiene or health reasons. The DDA overrules that, and it very clearly states guide dogs any assistance animals. So there are assistance animals with people that may sense the onset of epileptic fit, assist with other parts of a person's life. So it's not just purely guide dogs, but assistance animals are permitted in. The only area where there are typically restrictions is in healthcare settings like health hospitals and the like. So the disability access to premises sits directly under the DDA. So there's the access to premises standards, and there's the access, or DSAP, which is disability standards for accessible public transport. Those two sit at the same level, and they provide administrative and prescriptive requirements that need to apply to buildings. Now, in New South Wales, for example, they adopt the premises standards. In Victoria, we have to do things in a more difficult manner. So the administrative sections of the premises standards have actually been embedded within the Victorian building regulations. So the building regulations list what the triggers are to apply access. The prescriptive requirements are then what's incorporated into the Building Code of Australia, which are directly taken from the premises standards. So that then says how you provide access and the methods of access and how you design things to provide access. The BCA then, I'll keep going, premises standard. The premises standards, building regs, is not applied retrospectively to building unless there's complaints and those complaints are upheld. Applies to new buildings, portions of existing buildings being upgraded, or all portions of existing buildings subject to major alterations and additions or change of use. It's created a new benchmark for any access-related complaints under the DDA or Equal Opportunity Acts. So when the premises standard came out and was embedded back in 2009, we were all told that if the building complies with the premises standards, owners, managers, and the like are indemnified of complaints for discriminating on terms of access. So because it's not retrospective, if you haven't got access into the building, you don't have to then provide access to the building unless you trigger a few of the items which we will discuss. But that all changed a couple of years ago, and we'll get into the understanding of that. The premises standards, however, has detailed now responsibilities. So any building works that triggers a building approval will require the conditions within the premises standards, building regs and BCA to be applied, and all parties on that list you see in front of you are now held liable to ensure that is achieved. And it can have significant financial impacts, which we will discuss shortly. The Victorian building regs, Reg 236 is the most referenced one in terms of access. It has incorporated some new things, new part, affected part, which is a critical issue, which we'll discuss. It has provided concessions for lifts. So lifts comply to the old codes, and there's no requirements to upgrades, and toilets, and there is also built-in concessions for apartment buildings. So the building regulations then trigger the Building Code of Australia. We've got Volume 1, which is commercial and also multi-level residential and the like. Volume 2 covers Class 1A or housing, and Volume 3 is plumbing, but we never open that. So Volume 1 is legislation on how all buildings must be constructed to achieve compliance, covers the intent of the Disability Discrimination Act in environmental efficiency, fire, life safety, provisions of sanitary facilities and the likes. One of the good things they changed a few years ago was they made it a free download. So you can just go onto the Australian Building Code Board website and download it. And if you suffer insomnia, you can start reading it. Some typical Australian standards, and these are probably the key three ones that are referenced in the building code dealing with access. We have 1428 Part 1, which is the general access requirements. 4.1, which deals with the tactile ground surface indicators, which are the dots you often see at the tops and bottoms of ramps. And Part 6, which deals with off-street parking for disabilities. I should also add, because it hasn't been mentioned, this presentation will be distributed to all attendees. So even though I'm going through slides fairly quickly, don't panic. You don't have to take notes. They'll all be there available for you. So one of the good things in the exemption, it provides some exemptions. So it provides exemptions to meet the premises standards requirement to lessees and multi-tenanted buildings. Lessees are required to make their own works in their own premises comply. And this is typically where you might have a mixed-use building, you might have retail, might have offices, but then you also may have residential sitting above that. So in this circumstance, if you take an office within a building and you want to do an office fit out, you are only responsible up to the entrance of your building. You're not responsible for compliance from the entrance of your tenancy to the principal entrance of the building. Ditto lift concession. If the lift travels more than 12 meters, you aren't required to bring it up to compliance with the current standards. And the key difference there is under 12 meters, the lift car only needs to be 1100 by 1400 floor size. Over 12, it ends up going up to 1400 by 1600. So we realise it's not easy to modify, or it's not nigh on impossible to modify a service core in a building to make lifts bigger. So there is a concession. Ditto, if there's public accessible toilets within the facility that are designed to the previous standards, there's no requirement to bring them up to compliance with the current standards, which is the 1428 Part 1, 2009. The premises standard has also exemptions for lessees. Oh, sorry. Under Part 4, under Part 4 covers the lessees. So again, with the premises standards, the building regs, these are free requirements or regulations that you can download. There is a provision again for unjustifiable hardship, and you can, I'm trying to think the best way to word this. So it's not unlawful to not to comply. However, you can be open for complaint. If that complaint goes to any of the tribunals, you can argue unjustifiable hardship. But as I said earlier, you're going to have very, very strong arguments. Part of the application, and for Victoria, the application's a 160B application. You have to jump through a lot of hoops. There's you have to show organisation, and in this case it would be OC's financials to demonstrate we don't have the money to do that. They'll then probably ask, can you levy the owners? So it can be extremely onerous. Key considerations that they'll ask for is the nature and the benefit of detriment, financial circumstances, so the capital costs, operating costs, loss of revenue, if you do it or you don't do it. And loss of revenue, a classic case could be you could have a standalone cafe that they do alterations and they might have 3 steps into the cafe. So to enforce compliance means installing a ramp, but installing that ramp may knock out a third or a quarter or even more of their tables for table service. So now it does have cause a loss of revenue. So those sort of items will be considered by the Building Appeals Tribunal. Ability of financial assistance, is it a public or community, nature of the building, technical limitations, topography, heritage, structural, and if you've got a disability action plan in place, prepared and implemented. So a DAP could say, okay, we can't get access into the principal entrance of the building. However, we can provide assisted access through a side entrance, or we can provide access through another building foyer to give us access into our tenancy. It can be a bit problematic if there is a change of use to the tenancy. So you might go from a Class 5 office to a Class 6 cafe. That can be sometimes a bit difficult to negotiate, but having a building surveyor on board usually will assist with that. And the problem is when you trigger change of use, rather than just addressing the works that you're wanting to change, you actually have to bring that whole tenancy or building up to full compliance with the current Building Code of Australia requirements. So as I mentioned, the Building Appeals Board is where you would lodge such applications, very onerous, high burden of proof. Typically takes around 3 or so months to get your application prepared, and usually another 3 to 4 months to have it heard by the Building Appeals Board Tribunal, and then for them to rule on a decision. The strike rate of getting approvals through, even to this date, is still very low. We've got one going in it at the moment, and we've got one of the top building lawyers, Bromley, preparing that for us out at Pentridge. But yeah, if you need to, you can. I'll mention a bit further on, sometimes you just bite the bullet and do the works because all the legal fees and legal works and everything you do ends up costing more money than it would have been to do the works in the first place. This is a requirement I mentioned earlier about the lift requirements, or not being triggered over 12 metres. These are the requirements. I won't bore you to read through it, but have a read yourself when you get a copy of the presentation. But it talks about why you don't need to upgrade accessible toilets within a building if you do building upgrades or amenity upgrades. And again, it's because typically accessible toilets are located like lifts within service cores. So you've got structural walls around all four sides that you can't move. So the Building Human Rights Commission recognised this was going to be an issue and has provided those conditions. Now, the next issue we're going to talk about is new part, affected part, and this is something very important. With any building you're looking at doing upgrades on, doing refurbishments, extensions, modifications, change of use, anything like that, you will trigger what's called new part, affected part, which is in Regulation 236 of the building regulations. And what that says now is any area of new works is defined as the new part. You are now required to get an accessible path of travel from that new part to the principal entrance of the building. And that path of travel must be brought up to full compliance with current standards. Now, that might not necessarily mean knocking down walls, moving walls. If you've got issues with door circulation, door compliance, the Building Code of Australia is a performance-based document. So you can achieve performance in three ways. One is what we call deemed to satisfy, and that's meeting the prescriptive requirements 100%. The second way is via performance solutions. So we can look at a project and go, okay, we have insufficient door circulation here and we can't get compliant access into the building. What can we do? Okay, if we automate the doors, can we offset that door automation to not providing the required circulation spaces? Typically in that situation, we can get that through. So we achieve performance by automating the door. And the third method is a combination of both prescriptive and performance. So it's not the end of the world when you have to achieve compliance, but it might just add a few extra dollars onto projects to get the affected part compliant. So a typical example is if you had a rooftop recreation area or decide, okay, let's open up the rooftop and set up a barbecue area, recreation, social area, you now need to ensure that area is compliant, but it is then going to trigger affected part. That affected part will include vertical transportation. So it'll mean, does our lift comply to current standards? So you might find, okay, yep, we get our lift concession, so our lift car size is fine, but our lift controls don't comply to standards. Our floor notifications don't comply to current standards, which will mean a retrofit typically to the interior of a lift to bring it up to current compliance. So they are some of the things you need to be aware of. So here's an example of affected part doing works at the back of a training area. So all those doors from that training area to the front door need to be then brought up to compliance. If we have a two-story building, we've got without a lift, we will now need to put a lift in if the first floor is over 200 square meters in area. If the first floor is less than 200 square meters, and this applies to first, second, and third, less than 200 square meters, you do not trigger the requirement for a lift. So that's an important one to bear in mind. Most buildings, if they're over 200 square meters, if you haven't got a lift, you'll be putting lifts in. Now, as I mentioned earlier, there is the lessee concession. So for a lessee, and how this is worded in the regs, if the lessee of a new part, i.e. new building works of a building, submits an application for approval for building works, the following people do not have to ensure the affected part of the building complies. So the certifier, developer, the building manager are exempt from having to consider affected part. Hence, affected part does not get triggered, and you do not have to worry about that within your own tenancy, within your own apartment, if it's residential or anything like that. So there is a important concession there, because it's fair and reasonable to accept that an individual doing their own tenancy and the like should not be held responsible for paying to upgrade the common areas within a property, be it foyers, lifts, and the like. Now, there is an apartment concession. So for apartment buildings, typically they're class 2, sometimes might go into class 3, but typically they're built under building classification class 2. So if a building was constructed 1st of May 2011, the importance of that date is when the premises standard was enacted or incorporated into the regs in the Building Code of Australia. So if it was built before a building application was submitted prior to 1st of May 2011, the internal parts of the sole occupancy unit of a class 2 and also the common areas of a class 2 building, the entrances of a class 2 building, the external approaches and the like, do not have to meet these new requirements. Or at least we thought. A couple of years ago, there was a case that went through VCAT, Black versus Owners Corporation, 2018, so 4 years ago. So where a resident developed a disability that required her to use a wheelchair or scooter. She had difficulty accessing her apartment because she was unable to operate the entry doors, and the ramp from the car park was unsafe for her. The resident sought in order that the OC make adjustments to the common property so that she could then access the building. The Owners Corporation, rightly or wrongly, said, no, we don't have to do it because we have an exemption under the premises standards. Henceforth, we aren't going to spend the money. We're not going to make it accessible. You either pay for it yourself or find somewhere else to live. So she, in her case, she lodged it with the Equal Opportunities Commission, which then went to the Victorian Civil and Administrative Appeals Tribunal. They determined if a resident with a disability requires adjustment to the common property to facilitate access, the OC must carry out the adjustments provided they are reasonable. So this now flies in the face of federal legislation. So now the question is, does state legislation have the power to overwrite federal legislation? What constitutes reasonable adjustments will depend on the facts of each case. Matters taken into account include the financial circumstances of the OC and the financial impact on it, and the consequences for the person requiring the adjustment if they are not carried out. The obligation on the OC operates separately to S56 of the EEO Act, or so the Equal Opportunities Act. Or is EEO, is that real estate speak? I'm not too sure there. Which provides that an OC must allow a resident to make reasonable adjustments to the common property at their own costs, provided a number of preconditions are met. So this was a big one. No one expected this, and it's really put all OCs on notice that you can't no longer hide behind the federal premises standards to be exempt from anything that triggers access. In practical terms, the OC may not be able to decide what constitutes reasonable adjustments without the parties obtaining a determination from VCAT. If VCAT finds the adjustments are reasonable and makes orders for them to be carried out by the OC, the works needed to comply with the order will be considered urgent, and an extraordinary payment from the maintenance fund may be possible. If there's insufficient funds within the maintenance fund, obviously a levy will have to be applied to all apartment owners within that building. This has been further reinforced, and whilst this isn't really OC, it is very similar. So Parliament Square was a $330 million development in the centre of Hobart. But it was lodged a complaint to the Tasmanian Anti-Discrimination Act because one of the key access points off Salamanca Place, which you can see in that top left-hand photo, was stairs, which meant people with disabilities, parents with prams, other people with mobility impairments and the like now couldn't access Parliament Square. They would have to go around to the other side of the property, but the footpaths and that were extremely steep, making it very difficult. So the complaint was lodged to the Tasmanian Anti-Discrimination, or under the Anti-Discrimination Act in Tasmania, not the Disability Discrimination Act, and it was lodged to the Tasmanian Anti-Discrimination Tribunal. A few days before the tribunal was due to meet, the developers argued that the Anti-Discrimination Tribunal couldn't hear the case due to the developer raising two defences: constitutional inconsistencies between the Commonwealth and state discrimination law. Developers had a defence under the Disability Standards Access to Premises Standards for the basis that the development complied with the standards. So now we've got a development that met the requirements, and the requirements were you have to provide access through the principal entrance of the development and 50% of remaining entries. So the developers, rightly under the premises standard, this isn't one of the 50% of entries that need to be accessible. We've got our principal entrance, we've got our other entries which are accessible. We just haven't got this one to be accessible. So the tribunal hear the arguments and dismiss the complaint on the basis they didn't have the jurisdiction to hear the case. Note, if the complaint was dealt with by the state body, they can't then lodge a complaint to the Australian Human Rights Commission. So again, that's an important point to be aware of. So an appeal was then lodged to the Supreme Court that determined the tribunal could and should hear the case, and referred it back to the tribunal for hearing and determination. The High Court asked two questions, and they were: can the tribunal deal with the questions that involves the federal standard? Whether the premises standards overrides the state anti-discrimination laws. So question one, the High Court decided at the time of lodgement, the tribunal the tribunal did have the authority and the jurisdiction to make a decision about the case, and the matter should in turn be referred back to the Anti-Discrimination Tribunal. And for the second question, whether the premises standards overrides the state anti-discrimination laws, no decision was made. We'll throw that in the too hard basket, and someone else can pay lots of money to get a determination there. The High Court was not asked to make a decision about the access issues. It was just purely on the legal grounds on who could hear the case. No discussion within the High Court about the complaint. So what does this mean now? So in the interim, the Tasmanian government has established a new body. So they've established their own civil and administrative appeals tribunal body, similar to what we have in Victoria with VCAT. And that was putting in place while it was going through the High Court. And all other states have similar tribunals. So if then you're not happy with the determination at VCAT, you then have to lodge a complaint on legal grounds to the Magistrates Court. So again, it comes back to what I said earlier. If you want to go down that next step, you've got to lodge that complaint as the complainant at your own expense and provide your own legal defence, which you hopefully get as pro bono. Consequently, not a lot of cases get to the Magistrate Court. The last one I remember was one dealing with Jetstar, I think, and the limitations they apply on their flights to the number of people with disability they carry. That happened to be unsuccessful. So, you know, if an OC wanted to be bloody minded on any issues whatsoever, they could basically say no. If the state tribunal then says, no, we're going to override that, you need to provide access, it would then be up to the owners' corporations to go to the magistrates court and say, we're challenging the decision of VCAT at the owners' corporation expense. So it's really a win-win for no one apart from the lawyers. So this now means any owner, tenant that requires reasonable improvement works to be done to a building to improve access, it is likely to be successful at VCAT. Should OCs choose to take it further, they'll need to appeal to the magistrates court at significant expense. In the case of the Hobart projects, the legal costs incurred by the developer were substantially more than the costs of installing a lift. So I think early on, you have to have a rational discussion with the OC, owners corporation, getting together and go, what could this cost us in legal fees long term? Do we just bite the bullet and spend, you know, 20,000 on a ramp, 30,000, 50,000, 100,000? Because chances are, if you want to fight it, you're going to probably exceed 100,000 or more. So it's an important thing you really look at. Liability. So my next question is, can OCs really be held liable? You know, can we fight this? What could happen to us, or could it backfire on us into the future? So back in 2001, there was a legal case. Toomey and his mates, which was a lacrosse team, were staying in apartments. So if you Google Toomey versus Sclaro Concrete, there's a lot of legal details about it. So I'm just going to skip over it briefly. Toomey came out of his apartment and to walk down the stairs. Two of his mates were mucking around and wrestling on the stair. At the landing, they knocked Toomey. Toomey went over the balustrade, fell to the level below, broke his neck, became a quadriplegic, and obviously went through the courts. In the end, Justice Jeffrey Eames decided that the responsibility of the case rests on a total of 9 defendants and awarded 2.248 million in damages. So remember, this is 2001. So we're probably triple, quadruple these sort of figures if it was to happen now. So 50% was to be paid by the 2 men wrestling on the stair. The bad news is the other 50% was equally paid by the 2 main building contractors. So we had a base building contractor and a fit out contractor, the apartment's architect, the building surveyor, the building inspector, the developer, and the building manager. And I would suggest then the building manager would bring in the owners corporation into their legal case on that basis. So my question to you is, do your buildings comply? Are the balustrade handrail heights correct throughout your site? So that can even be in fire stairs. Are the TGSIs designed, and is the luminance contrast correct? So we know at every ramp and stair, we need tactile ground surface indicators to flag for people with vision impairment that there is a hazard ahead of them. Is the design compliant, and do we meet the luminance contrast requirements so they are at least detectable? Why do we worry about a stud that's textured and luminance contrast? Because depending on the disability conditions, and you could have someone say diabetic, they may not have sensation in their outer limbs, so they won't pick up the texture, but they will pick up the luminance contrast vision difference. So they try to incorporate many universal accessibility elements into the standards to cater for the maximum amount of people. And this is a big one. Do the stair nosings comply, and is the luminance contrast correct? So this is as critical as tactile ground surface indicators. So on all your stairs, you need complying stair nosings. Do they meet the luminance contrast? Do they meet the non-slip requirements? Occasionally we get drawn in on legal cases or by insurers to say, hey, we've had a slip, trip and fall at this premises on these stairs. Can you please go do an assessment on them and tell us whether they're compliant or not? Our report then gets inserted in as expert evidence. So nosings and ramp gradients, handrails are probably the most common areas where there are slips, trips and falls. So do they comply? Because it doesn't matter if they complied when they were installed. If they don't comply now and there is a fall, you will be liable. Ramp gradients compliant. Does full height glazing include the contrasting band? So it's a glazing strip that goes across the face of the glass to prompt people to stop before walking into the glass and injuring themselves. A door opening sufficient? Can people in wheelchairs actually get through the doors? Is the force to open those doors no greater than 20 newtons? Because if they exceed 20 newtons, someone in a wheelchair tries to open the door, their wheelchair will move and they won't be able to get in. Again, risk of injury, risk of complaint. And they're probably the key things for OCs you really need to be aware of. You will be held liable for slips, trips and falls. You will be responsible for reasonable adjustments for accessibility. And it could be just resident has had a motor vehicle accident, or they've might have had a stroke, or for any other reason, they've had an accident and they need reasonable adjustments to get into the common areas of your buildings. OCs aren't responsible within their own tenancies or within their own apartments, but at least within their tenancies they are. That's it. So any questions?
Fantastic, Bruce. Well,
we're right on time.
Thank you very much for sharing your insight with us all this evening, and also your vast experience, and obviously very relevant for owners corporations and other situations as well. We've had a few questions come through. I have a few questions myself as well. We'll start with, I guess, the scenarios. So if there is an old apartment complex, so we're talking about a pre-1st of May 2011 apartment complex, a couple of levels in height. Mm-hmm. Now the base of the apartment complex is in excess of 200 square meters. Mm-hmm. And the owners corporation decides to undertake works to the rooftop to either install a community garden or to install a barbecue area, which was something you mentioned. Mm-hmm. Would there be a requirement for the owners corporation to install a lift if there wasn't a lift installed already?
Yes, it would.
Okay, interesting. All right.
Again, it comes back to that affected part. You've got that part of the existing down to the new principal entrance. Okay,
and in terms of if the structure of the building prevented a lift to be installed, would that be a factor that comes into play?
Yeah, and that's where the building surveyor will tell you you need to go for a 160B exemption, and you'd have to lodge seek to get a dispensation through the Building Appeals Tribunal.
Okay, interesting. Thank you. The other query for myself would be in relation to something that you really haven't covered, but still relevant. In the case of apartment complexes where there's lifts or stairwells, in the event of a fire or another emergency where the occupiers of the property would need to be evacuated. Mm-hmm. For those people with a disability, more so for people in a wheelchair, if there was a requirement to evacuate, obviously the lift is shut down and the stairs recommended to be used. Mm-hmm. Are you able to shed some light in regards to the best approach for someone in that situation, whether they have to register with the Fire Rescue Victoria, which is formerly the MFB, or even with the owners corporation themselves to, I guess, promote the fact that there is someone in an apartment that needs some help in the event of an emergency?
Yeah, there's a lot of talk online at the moment. If you get onto LinkedIn, there's a few of us chatting about this, particularly in light of Grenfell, where I can probably do another 1 hour presentation on emergency evacuation planning for apartment buildings. And yeah, that might be something we talk about in the coming months. It is very problematic. We have a building code which does not set any prescriptive requirements dealing with the evacuation of people with disabilities. It does for everybody else, but if you've got a disability, the Building Code of Australia and the ABCB obviously don't think you're important enough to actually seriously address it. To me, some of the things that should be done at your fire indicator panel, you should have a register of residents in there who have disability and will need assistance. So as soon as the first responders hit site, they'll go to that FIP and it'll list who's living on what apartment and who's going to need assistance to get out. That form of assistance can be in a number of different forms. Just bear with me. The most common typically is evacuation chairs, but then you've got the situation, do we have people living alone or with partners or someone like that? If they're living alone, obviously they can't use the chairs. However, having a chair within the apartment can assist the emergency services to get that person out very quickly, very safely, and not tie up their resources. I'll just see if I can find a quick snapshot video to show how these. So these are a device that have got a belted track at the back. If I can get to it. Okay, there we go.
Okay.
So these devices. So if the emergency services get there, they find an evacuation chair, they go, great. One fiery can evacuate a person with a disability quickly and safely, as opposed to having a manhandle, typically 4 people carrying a person down in their wheelchair or just carrying them directly. So that's probably the most easiest technology to use. You do have things like evacuation sleds. Again, you need another person in the household. So if you've got someone in the household that can be trained to use the evacuation chair, great. But otherwise, you just have the evac chair, again, labelled in the fire indicator panel, Mrs. Jones, apartment 2, level 3, evacuation chair available. So the fireys know, okay, we'll send 2 people up there, not 4, and they can get into the apartment, get the chair set up, transfer her on, and bring her straight down. So I think at the moment, having it in the FIP is about the only real suitable way of doing it. The discussion after Grenfell in the UK is the recommendation from the Royal Commission was PEEPs must be provided. The British government is fighting and resisting that requirement at the moment. So it hasn't been enacted, unlike the other preliminary recommendations, but yeah, that side of things is still up in the air over there. And unfortunately here, it's ignored.
Well, interesting, and certainly I agree that the registration of residents at the fire indicator panel cabinet would be certainly the best place. So something for our managers to speak with the owners corporation committees about to promote.
As I said, I'm happy to do a presentation on evacuation planning, and probably even what we haven't spoken on today is how do you actually make buildings comply, or what is non-compliant. We can certainly cover that in another presentation quite easily.
Fantastic, that'd be terrific. Thank you, Bruce. There's actually a question in the chat about, will the Knight be recommending that checks of buildings is undertaken to identify any compliant areas? And we do, in fact, in every AGM agenda, talk about the requirement for OH&S compliance, and we certainly encourage owners corporations to engage experts to do inspection and testing of that. So something it sounds like you can do yourself, Bruce, your company. So a bit of
Yeah, certainly.
Great.
It's sort of bread and butter for us.
Thank you very much, Bruce, for your time, and hope you enjoy your daughter's concert this evening.
It just came up last week. I was told about it before, so my apologies for having to duck off early. So.
No, not at all. It's been a fantastic presentation. So once again, thank you, Bruce.
Excellent. Thanks, everyone. Cheers.